2024. This is the South Coast Air Quality Management District Hearing Board. Today we have on our agenda the first item for the City of Burbank, Burbank Water and Power, case number 1474-30 for a regular variance. It is going to be rescheduled and is off calendar. We also have the Chevron Products Company 831401 for an emergency variance, and that is on the consent calendar. And we are going to be recessing for about 5 minutes or so. We have one member who's he's almost here. So we're gonna go ahead and recess and come back. So if you can stop the recording. Thank you. Okay, we can restart the hearing. Thank you. Okay, all members are here. We again are going to have the Chevron Products Company case number 831401. It is for an emergency variance regarding rules 203, 2004, and 3002, and it is on the consent calendar. So we are going to be marking our exhibits. Within the petition, there is 1 through 3. And then number 4 is the joint stipulation to place the matter on the consent calendar. Number 5 is the declaration of Andre West for Chevron. Number 6 is the findings and decision of the hearing board. And there's also an attachment with number 6, which includes the proposed short variance conditions. And then we have two email strings. So these are going to be identified as HB1, and that is for the one that is dated Wednesday, April 17th, 2024 at 1:35 p.m. And then HB2 will be for Wednesday, April 17th, 2024 at 6:47 p.m. And all of these exhibits will be entered into evidence. Okay, with that, we can go ahead and start the deliberation in regards to Chevron Products and why they needed this variance on an emergency basis. And as we have mentioned before, we just had them, I think, a week ago with something similar. But anyway, it was to repair the caustic solution flow meter in the C2180 caustic scrubber. And this was at the Chevron refinery that's located in El Segundo. And the need for the emergency repair is in regards to the variance coverage for both the unexpected and the unforeseeable, and not the product of either operator error or neglect. So it was to maintenance, and that was performed on the C2180 caustic scrubber on March 11th, 2024, and the equipment appeared to be performing properly at that time. But on March 27th, they experienced an unanticipated failure of that flow meter, which measures the flow of the caustic solution into the scrubber. So did we want to go on from there, and comments from board members? Mr. Pearman?
First, make sure we ask for public comment at some point. And secondly, I presume we do this bifurcated for good cause first for the emergency situation.
On the emergency, Madam Clerk. Okay, so let's go ahead and do the for good cause. And I in particular do feel that there is good cause because it wasn't unanticipated, and they were going to look at this item during their regular maintenance, and it just happened to break down before. So I can find good cause. Any other comments?
Yeah, I think the good cause finding is the for good cause finding, and they adequately pointed that out. They were in violation of the rule, permit condition that required the flow meter to be operating. So the rules they cited that the circumstances leading could not have been avoided in sufficient time to provide public notice. So there's no public notice to the community around El Segundo. It's just the notice that it takes place routinely because of the Brown Act. So then, but at the same time, they also, I think the third one is whether they exercise diligence, which they clearly did. I think within a few days they filed for the emergency variance when they realized that they couldn't actually repair it. They thought initially there was a plugged line, but then they found out it's something more serious. So then they filed for the emergency variance, and the denial of the variance will be it's an unreasonable and unavoidable impact to the petition. Right now, it's not operating. It's a standby mode, so the emissions are almost there are no emissions at this point. So I think for all those reasons, the good cause exists. They made the finding for good cause, and I think we can grant good cause and move on to the next phase.
I agree. Dr. Abraham?
Same.
Okay. Any other comments? Okay, so let's go ahead and see if there's any public comments, Madam Clerk. Okay, with that, I'll entertain a motion.
Sure, I'd move on this initial phase of the hearing on the good cause for granting an emergency variance. Respect to case 831401. The property is at 324 West El Segundo Boulevard. Equipment is Chevron C 2180 caustic scrubber. The rules in play are District Rules 203B, 2004 F1, and 3002 C1. Fine based upon the facts set forth in the stipulated papers, including the proposed findings and decisions at Exhibit 6, that the 4 points for good cause have been met, and therefore we can grant the emergency nature of this variance and move on to its consideration on the merits.
Do I hear a second?
Second.
Okay, and any discussion on the motion? Mr. Balagopalan, how do you vote?
Yes.
Mr. Pearman?
Aye.
Dr. Abraham?
Aye.
Mr. Ali?
Aye.
And I also vote aye, so that's unanimous. So now we can go on to the second part of it, which is the actual vote for the emergency variance. And I think we've stated basically what the situation was. Are there any other additional comments to that?
Yeah, I was just reading what the criteria for emergency variance appropriate in circumstances with good cause, which we just found justify holding the hearing in absence of notice to the public. So that we just agreed upon. And then the next is the six findings can be made, which we have to do. And then the third is the violation will be remedied during the period of emergency variance or under further variance relief. So they have, I think it, according to the reply that I got, they are going to start on the 22nd. So, and they need about 7 days. So they'll probably be the period of the emergency. They will be able to do it during the period that we're granting them. But they have also applied for a short variance, and so that's with public notice, and that's slated for 4/30/24. So they've met. So they've met all those 3 criteria, and I think the 6 findings that also they have clearly articulated that in the finding and decision document that the petitioner is in violation of the rules and that Mr. Pearman just mentioned. In addition to that, they are, in addition to Rule 203B, 2004 F1, 3002 C1, they also are in a violation of the permit condition C 8.16 and administrative condition 2 and 4. So those are the things that are in violation of. So then the non-compliance is beyond the reasonable control. There was a malfunction. They found out what the cause is probably a root valve, and so they have to replace that. So, and so that's the it was really beyond their control. The third is requiring compliance would, not granting them variance and requiring closing it it'll be without corresponding benefit, reducing air contamination, because the unit is not in operation. The caustic scrubber is, they have to maintain a flow, so they are still maintaining the flow. And I think there's a condition that they will look at the RPM and use the RPM as a surrogate for the GPM. And so that's one of the conditions that's in the proposed findings, so that they will still maintain the flow, but it's not sure whether it's really 200 GPM as required, but they had some correlation between the speed and the flow. So also the reply got, the inspector was out there and he saw it, and I think he was satisfied that there would be a good surrogate. So the closing would be without a corresponding benefit, reducing and contaminant. So essentially, nothing is vented 99% of the times. This is a standby unit. I didn't realize till when they replied, and so and they have another 5 H2S unit where they can route the H2S gas to. So, and then the other finding is that they're given consideration curtailment operation. So really they, at this point, they cannot really curtail or terminate the operation because that'll lead to excess emissions. So, but, and then during the period, the various factors that will reduce emission to the maximum. I think that the condition that is in the proposed order that will reduce any excess emission to the maximum feasible, and they will also be monitoring. So they have the SEMS, and there will be conditions that in the proposed order that will require them to monitor document flow. And I was going to, there's one other thing that we have to add, which is temperature. I did check with them. It was in the finding and decision document, but they didn't add it to the order condition number 3, which says the petitioner shall monitor and document flow. It should be then comma, temperature, comma, inlet pressure. They had worded it as temperature, inlet pressure, but that surely should be a temperature, comma, inlet pressure. Is it a different parameters? So they will monitor those in addition to that. So, and then I think they've laid the conditions are all laid out in the proposed finding and decision document. So they have met they have demonstrated that they have met the 6, they will meet the 6 finding. And so I think we can grant the emergency variance based on that.
I agree with all your comments, Mr. Balagopalan, and appreciate the fact that you did go a little bit further and question them on the other issues that were stated within that, the hearing board 1 and hearing board 2 email string. So is there any other discussion on the matter?
I think hearing board 1 was Mr. Payman had a question, so
yes,
they replied
yes,
that,
yes.
and 2 was mine. So
Pardon me.
So we're ready to make the motion?
Yes, okay, did you want to, what?
oh
Go right ahead.
oh
No, go right ahead. It's-
no,
It's perfectly fine.
sure, okay, all right, okay. So in the matter of Chevron Products Company, case number 831-401, I move that we grant an emergency variant in absence of notice to the public, commencing today and through May 18th, 2024, from the following rules and subsection. That is 203B, 2004 F1, 3002 C1, and condition 8.16, and administrative condition 2 and 4 in section E of the Title V permit, facility ID 8000030. And for the equipment, I think which already been cited by Mr. Payman, where it's located. The specifically it's a scrubber, but I'll just mention it again. It's
C2180.
C2180, yeah, caustic scrubber C2180, and for the it's located at 324 West El Segundo Boulevard, El Segundo, and there's no excess emission anticipated during the period of the emergency variance, and the conditions are as proposed in the finding and decision document, with the change to condition number 3 that I just mentioned, adding the word the temperature in the condition number 2.
Okay. Yeah, motion made and second. Any other comments on the motion?
Just one, we did ask for public comment on the matter already, so I don't think we need to do it for each part of the bifurcated proceedings, just that we
No,
did
we
it for
don't.
the matter at all, so that should be sufficient.
Great, thank you. Okay, so with that, Mr. Ali, how do you
Aye.
vote? Dr. Abraham? Mr. Pearman?
Aye.
Mr. Balagopalan?
Yes.
And I also vote aye. And I think this was a good example of how this all comes about, especially with such a large facility that they have out there. So I appreciate the work that the district did, working with Chevron and their attorneys as well, and their representative, Mr. Andre West. So, and I also thank my board members for coming here today and deliberating this subject. So thank you, and if there's nothing else, we are adjourned. And you can stop the recording. Thank you.
Thank you, folks.